The All India Muslim Personal Law Board, meanwhile, has said that it is not satisfied with the judgment. Here's the reaction for you.
Judgment is not satisfactory and is not as per our expectations. We are not satisfied with it, and especially from the fact that the land of the mosque, even of the inner courtyard, in which prayers were offered, that too has been given to the other side. And whatever legal course is possible, that we will adopt.
And Ramakant Gaur, a constitutional expert and lawyer, joining us live from New Delhi now for his perspectives. Thanks very much, sir, for speaking with us. If you can begin by sharing with us your initial reaction to that verdict that's come in, a decades-old dispute that's been put to rest today.
Undoubtedly, it will put a rest to undoubtedly, in fact, the litigation started in this case in 1885. A round of litigation happened after 1950 onwards. Allahabad High Court acquired the jurisdiction to decide the civil cases there, and various technical perspective had taken place. But this is a judgment which happened in Supreme Court after 40 hearings, whereby they examined the threadbare evidence. Normally, Supreme Court would not consider the evidence, the facts of the case like this. And initially they started with, the judgment starts with, this is a dispute of a piece of land, 1,500 square feet of land, whereby two communities are claiming their possession, they're claiming their title, right and interest. So this dispute has been put to the rest by a constitutional bench, whereby the central government has been asked to frame a scheme under which the inner and outer courtyard will be given to Ram Janmabhoomi Trust in 3 months. An alternative, as a compensatory measure or as an alternative, Supreme Court directed the Government of India to provide a suitable plot of land measuring 5 acres to be handed over to Sunni Waqf Board. So Sunni Waqf Board has its own reservation. They say we are not satisfied and they'll go into review. But Supreme Court has marshaled these evidence, facts and the law in 1045 pages and then beautifully carved out the disputes and extracted the facts of the case, put the law into it, amalgamated law into it, and set the controversy at rest. If you look at the the evidentiary value of whatever has been put by the rival side, the Supreme Court observed that the disputed side is one composite whole. That means 1,500 square yard site is one and whole. You cannot do like this, that you divide this in 1/3 of the piece of land, give it to the various parties, and make an amicable solution kind of thing, which was given by Allahabad High Court. Supreme Court has set aside the judgment of Allahabad High Court and then said the disputed site is one composite whole, and there has been no subdivision of the land or any determination of the title. One more thing which has happened, which is decided, that the Sunni Central Waqf Board has not established its case of a dedication by a user. That means, and then there was an alternative plea of adverse possession by Sunni Central Waqf Board, that they have been using this for so many years, and that is why Hindu parties cannot claim the title and interest into that. Then Supreme Court discussed about demolition of mosque in 1934, and then discussed about 6 December 1992, and finally decided that the Hindus have established a clear case of a possessory title to the outside courtyard, which was admitted by every party. So Ram Chabutra, or the outside courtyard, was the place where Hindus were performing pujas since 1950. So adversary title claimed by Sunni Waqf Board was discarded, and they say that Hindus were already there. As far as ASI evidence is concerned, Archaeological Survey of India has specifically mentioned in their report that the mosque was developed on the structure where there was something beneath it, and that something had some sites, some idols, some structures like architectural structures like they were there in earlier erstwhile Hindu regimes, and it is like of a temple. And K.K.
Right.
Muhammad was one of the ASI members, has said that we were of the same opinion.
Absolutely. Now, this trust that will be set up over the next 3 months, constitutionally speaking, help our viewers better understand what the procedure will be during this time period, what the next few steps will be.
See, creation of a trust or handing over the land to the trust should not be an affair of more than 1 month. The judgment of 1045 pages would be elucidated to all. It will take time for everyone to learn and understand what are the guidelines. This is the operative portion what we all are discussing. But 1045 pages is the amount of document which we need to look into, and we need to, and everyone needs to understand. But it can be complied within 1 month, and as a matter of fact, a trust can be created. It can be created in not more than 7 days' time if it is delayed, even if it is delayed, and the handing over of the land to that trust should be done within the month of November.
Right, and the Sunni Waqf Board has been given that alternative piece of land, 5-acre piece of land. They have said that they might file a review plea. So where do things go from here if in case that decision is taken by the board there?
See, review against such order by the Supreme Court would fall. I mean, I don't say that they have no right to file review. They have right to file review. We see that happening in some cases in Supreme Court, but the scope of review is very limited. And this is a case where I don't think that they are able to make out even a prima facie case. And when they fail, that's the reason Supreme Court has discussed the facts in so much of detail. Let them file review, but I don't see anything which would be good for them.
All right, we're going to leave it there for the moment. Ramakant Gaur taking us through the nitty-gritties. Of course, it's a 1,045-page long verdict that's been delivered in that decades-old dispute. It's been put to rest now.